Now, before I begin, I'd like to introduce myself. My name is Eric Nakano, and I'm the staff attorney at the Self-Help Center at the downtown courthouse. This is run by a legal nonprofit called Voluntary Legal Services Program, and we've been in operation for roughly a year and a half. During that year and a half, we've assisted thousands of people. Actually, about 7,000 customers have come through. And this presentation is built on part of the experience that we have had handling and assisting self-represented litigants make their way through the court system. Now, before we go into anything, I'd like to begin on just a little bit of a personal story. I absolutely despise legal dramas on television. I watch these programs, and one of the things that I find myself doing is objecting during the courtroom scenes. Every time an issue of law comes up, I find myself going at the TV, that's not right. Now, I suspect that I love medical dramas, and I suspect doctors do the exact same thing during medical dramas. But I think ultimately the difference between the two is that when you finish watching a medical drama, there are very few people, if any, that have ever walked away from an episode thinking that, you know, I should go out and perform an appendectomy. Nonetheless, one of the most frequent things I hear from people when talking about the law is that, but it wasn't like that on television. So the fact that you're here today, I'm hoping will get you on the right foot as far as beginning a civil case in court. And with that, I will start by just letting you know that almost everything you have learned on TV about the law is wrong. I've even got a handout to that effect inside your packet. Whoops. My first mistake of the day. Now, before we begin, I'd like to go over a little bit about what the scope of this class is today. This is designed to be a basic introduction to starting a simple civil lawsuit. It's not designed to go into depth on any particular subject, just to how to handle some of the simplest cases in their earliest stages. If you are trying to file a complex 42 U.S.C. 1983 civil rights claim, we're probably not going to have much that's all that useful for you. Or if you have very specific questions about a particular area of law, we're not going to be covering it today. This is just an overview designed to let you know how to start a case and where you might find some additional information. Now, some things we are specifically not covering are filing lawsuits in the federal courts. We are only handling the Superior Court today, and specifically we're focusing on Sacramento County's rules. We are not covering small claims court. The process there is different, and the forms are different, but they're fortunately a lot easier to navigate. We're not dealing with family law or probate. Once again, these have different forms in a completely different system. And finally, criminal and traffic court, we're not even touching it. So the first question I want you to ask yourself is, why are you filing a lawsuit? Now, the basic answer to this is because somebody has done something wrong and it has harmed you. Now, there are a few different theories that you can raise a lawsuit under. The first type of wrong would be under contract. If you have a contract with someone and they break that contract, or they do something else that's prohibited under that contract specifically spells out what each person is supposed to do, and in some cases even spells out what the penalty for not doing it is. These are some of the easiest cases to handle because you know going in exactly what each person needs to do. Well, the other theory you might bring a lawsuit under is tort. Now,
I'm sorry to interrupt. We're having a problem with our
all right, one moment. Thank you. There we go. I think I just stepped too far away from the base, so I'll be reaching over here, doing my Vanna White to the slides. All right, tort. While contract spells out the rights between individuals who have entered a contract, tort is a fundamental wrongdoing based on the idea that every person in society has a certain set of obligations to every other person in society not to do certain things. Some of these are going to be pretty self-evident. If you're walking down the street, you pretty much have a duty not to walk up to somebody and punch them in the face. They call that tort battery. A lot of these will be simple. Some have a few, are a little bit counterintuitive and have a few more elements that you're going to need to research, but the fundamental concept is a tort is a wrong based on a duty each person owes to everyone else in society. And finally, there are statutory claims. There are some laws that allow, as a remedy for someone breaking that law, a person to file a civil lawsuit for either damages or some other form of enforcement. One of these might be, for example, violation of the Fair Debt Collection Practices Act, which allows a person who's been wronged under that act to file a lawsuit and seek damages, and they even set the amount of damages within the statute. Let's see if we turn now. Next question I want you to ask yourself is, do I really want to bring a case in the Superior Court? Because lawsuits are a long, slow, drawn-out process, and you may have some alternatives to actually bringing a lawsuit. One of these is, of course, you can negotiate and settle with anybody at any time. If you have been wronged, one of the first things you might want to do with somebody is to talk to the person and ask them to write it. Write them a letter, demand that they fix it. This is usually your first step, because if you can settle it at that point, you've saved yourself all the time, energy, and expense of going to court. You and the other person might agree on mediation. Mediation is where a dispute is brought to a neutral third party, and the people come together and they discuss the issues from each of their sides and ultimately, hopefully, come up with some sort of compromise between the two that each of them can live with. The advantage of a mediation is that, while a lawsuit is generally a winner-take-all type of situation, a mediation will create something in between that everybody can live with. The sign of a good settlement is oftentimes, or a good negotiated settlement is oftentimes, that each side hates it just a little bit. Arbitration. Arbitration is where a case goes to a neutral third party who hears the case and makes a decision much like the court might do it. The difference is it's a less formal process, and it's usually a lot faster, and it's done outside of the court in many cases. Finally, if you're an individual and you're suing, and you can sue in small claims court for cases up to $7,500. You get one case at that amount and a number of different cases at a lower amount. But you might consider small claims court. The advantage of it is it's much, much faster. You'll get a hearing date within a couple of months and a judgment after that. It's actually, if you've ever seen the People's Court or Judge Judy, small claims court works a lot like that, but with less sass and usually much less entertainment value. But it is very fast. The disadvantage, of course, is that your appeal rights as a plaintiff are limited if you lose, and it's really not suitable for handling more complicated disputes, because you'll usually have maybe 15 minutes to present a case. Now, the next question before you begin any sort of lawsuit is you need to know who you're going to sue. And I know it's silly, but a lot of people that I've seen don't have a clear idea who they're suing. First question is, who is responsible for the harm that you've suffered? if you are to win a lawsuit, you must allege that somebody has done something wrong and prove it. And typically you sue the person who has done the harm. Now, one of the tricks that I wanted to share with you that I see all the time is when people are involved in automobile accidents, their first instinct is to turn around and sue the insurance company for the driver of the other car. While it's true that the insurance company ultimately pays the claim if it's won, their duty is a contractual duty with the driver of the car to pay if they lose and to defend them in court if they're sued. They're not the actual ones that did anything wrong. You are always suing instead the driver and or the owner of the other vehicle. Let's say the other side is a corporation. Corporations, LLCs, partnerships, these can all be sued as an entity. They are essentially legally people and can be sued in their own name. Additionally, partnerships, you can sue each of the partners in a partnership, at least the ones that have done something wrong, if nothing else. Finally, if you're dealing with a business that's a sole proprietorship, the owner is essentially the business. The owner is the person being sued, usually doing business as whatever the business name is. One last thing, if you're suing somebody who has died, you can bring claims against the estate, but this is only going to be worthwhile if there's actually any money in the estate. So if somebody has died and there's nothing there, you're probably just wasting your time and energy bringing a lawsuit. All lawsuits must be filed within a limited amount of time after the wrong has been done. This is called the statute of limitations. Now, the rebuttal I usually get from people is, but murder doesn't have a statute of limitations. The answer to that is, of course, murder is a criminal offense. In civil law, everything has a statute of limitations. Sometimes it's long, sometimes it's extremely short. The clock to file usually starts whenever the wrongdoing takes place. It can sometimes be told to a later date, for example, where an injury is not discovered until later. But the first date you want to concern yourself with is, when did the damage take place? And the next date you want to also be aware of is, when did you realize it took place, and when would a reasonable person know it took place? The clock stops on the day the lawsuit is filed. The time between those two must be less than the statute of limitations. So what are some common statute of limitations? If you're suing on an oral contract, it's typically 2 years from the breach of the contract. An important exception to this is going to be if the contract doesn't have a specific date of performance, in which case it's going to run from the date that the contract was entered. So if you and your friend decide that your friend is going to pay you back the money you loaned, but you just say, I'm just going to come back and demand it later and you're going to pay me, your statute runs from the date you made the agreement. On the other hand, if you say payments will begin on a specific date and then that person doesn't pay, they start running when they missed the payment. Problem with oral contracts is they're usually very, very hard to prove. So if you walk away with something else today, make your contracts in writing. It's much easier to, as a lawsuit. Plus, it gives you a 4-year statute of limitations, which is a nice bonus. Personal injury claims generally need to be brought within 2 years from the date of injury or the date of discovery of injury, or when the injury would have reasonably been discovered. So if you're in that car accident and you're injured, 2 years from the date of that accident. Property damage. This is actually an error on the slideshow. If you're going along with this, please mark out 4 years, 3 years. I should have caught that one before. 3 years from the date of the damage to your property. Fraud, 3 years. And there are statutes of limitations for all sorts of other things. Sometimes this is one of the more difficult cases, or difficult issues you're going to be researching in your case, is what is the applicable statute of limitations. One final thing that I wanted to warn you about. If you are filing a tort case against a governmental entity, you are generally required to file a claim within 6 months of the injury taking place or the damage taking place. If it's with a local entity, it's filed with the appropriate agency for the local entity. If it's a state entity, it's filed with the state's Victims' Compensation Board. The purpose of doing this is that governmental entities are immune from lawsuits. However, under the Governmental Torts Claims Act, if a person timely files a claim, the government will waive that immunity for certain types of claims and will give what is called a right to sue letter if they decide not to process and pay the claim. If you fail to go through this first step and you file a tort claim against a governmental entity, the first thing you're going to get back is something called a demur, which is a challenge to the case itself procedurally, stating that you didn't file your claim. Now, another area where you're going to need to file a claim is in employment law actions. Typically, wrongful termination or discrimination cases require you to file a complaint through the Department of Fair Employment and Housing, which is then usually concurrently filed through the Federal Equal Employment Opportunity Commission. Once again, they will process the claim and issue a right to sue letter if they decide not to grant your request. If you're really determined to go to court, you can also request that they stop their investigation and issue a right to sue letter sooner. And there are some strategic instances where that might be advantageous. Hopefully, if you are in one of those situations, you have an attorney who handles employment law because it will make your life a lot easier. Now, we talked about contracts, spelling out the rights that everyone has within a lawsuit. Some contracts require you to arbitrate your claim. One of the possible things if you are required to arbitrate your claim under a contract is if you file your lawsuit within the court, the other side might file a motion to dump it back into arbitration. So if you're required under the contract to arbitrate your claim, it's oftentimes easier to simply start the case through the arbitration proceedings. Likewise, some contracts allow either side to demand arbitration, in which case you're going to want to determine whether you want to handle this in court or whether you want to handle it in arbitration, and be aware that the other side, as their first response to their lawsuit, might be to demand arbitration and get it kicked over into arbitration. As a final note, before you even choose to sue, you want to consider the finances of your lawsuit. How much money is involved in this case? If you're talking about suing over a few $100s or even a few $1,000s, if you can take the case to small claims court, you might seriously consider doing that. These cases that are under a certain amount, they're not worth hiring an attorney as a general rule. They're also, assuming that your time has some value, possibly not even worth your time pursuing through the Superior Court, given the amount of time and energy it's going to take. But small claims court is a completely different matter. Win or lose, you'll have a decision and you won't have spent that much time on it. Next, is the person you're looking at suing worth anything? If you are suing somebody who's well insured or has assets or money, or who has the potential to have assets or money, well, then that's a good indication that it might be worth bringing the lawsuit, because at some point, even if they don't have it now, and if you win, you might be able to get it later. On the other hand, if you're suing somebody who is not insured, maybe who has nothing, maybe who's homeless, any of these things where they don't have it now and are unlikely to ever have anything you can collect in the future, you might want to consider whether or not it's worth bringing the lawsuit. It might be, because you never know. Even the most destitute person might win the lottery. On the other hand, are you interested in spending the amount of money it will take to file and bring your case for the chance that someone else might win the lottery? And finally, what will it cost you to prove your case? Different cases have different types of proof that's necessary. Contract claims are usually pretty straightforward. What do you need to prove a contract? Well, you need to show that the contract exists. You need to show what the conditions and terms of the contract were. You need to show that the person broke the contract, and you need to show the damages that were incurred as a result. Well, between yourself, the other party, and maybe a couple of witnesses, you probably, and other documents, you might have exactly what you need to prove that case. They're not that expensive to prove, relatively speaking. On the other hand, if you're bringing a medical malpractice case, the judges are not doctors, the lawyers are not doctors. None of us know whether or not somebody is acting within the reasonable standard of care for a doctor in the profession. The only people who can testify as to this are expert witness doctors. This means that to bring and prove your medical malpractice case, you are likely going to be spending between $60,000 and $100,000 to bring that case. Now, if the likelihood of your damages, multiplied by the amount of, the percentage that you're likely to recover, don't add up to what it's going to potentially return, the case is probably not a good investment. This is why I always suggest people who handle medical malpractice cases or who have medical malpractice cases to always seek representation, because if you have a truly good case, there is an attorney that will be interested in handling it on a contingency fee, although there are a lot fewer now that we've passed tort reform in California, which limits damages for pain and suffering. So they tend to handle only the best cases. Otherwise, you will want to determine whether or not you can financially survive the case. Now, before we start going into the paperwork, the last couple of considerations you're going to want to consider are, can you file the suit in California, and where are you going to file it in California? The first question is called jurisdiction. There are certain activities, actions, or agreements that give California the ability to hear a case. Typically, California can hear a case if one or more of the defendants resides in or does business in California, or if the damage or injury took place within California, or if an out-of-state business has significant contact with California. There are other, specific details, but the first thing is, well, how is this case tied to California? And if it's not tied to California, you're looking at, other than the fact that you're here, because it's going to be from the defendant's side, then you're probably in the wrong court. And we can talk about this a little more during question and answer. The next question is, which court in California do you file in? This is called venue. And once again, you're looking at, does one or more of the defendants live in the county in which you are filing? Did the injury take place within that county? Or was the contract entered into in that county, or was it to be performed in that county? If it's a corporation, does it have a principal place of business in that county? Or if they're individual owners of the business, is the business there, or do the owners reside there? In any event, you have to have some tie to the county in which you are filing. One of the common mistakes I see is you'll have a plaintiff in one county, a defendant in the other county, and The plaintiff will decide to try to do everyone a favor by choosing a court somewhere in the middle. Unfortunately, if nothing happened in that county, there's no reason for that county to hear it. He needs to go all the way to where that defendant is. All right. So here's the big question you're probably wondering. What forms do I need? Next time I'll slide closer. What forms do I need? To initiate a lawsuit in the Superior Court, you have to have a few mandatory forms. The first is going to be the civil case cover sheet. We'll see an example of that later. It's a form that's used by for statistical purposes that lets the court know what kind of case it is. That's about it. It's relatively easy to fill out. The summons. This document's going to let the other side know you're suing them, that they have 30 days to file an answer within, after the time that they've been served with the papers, and also the name, address, and address of the court, as well as the court number. And then finally, the complaint. And this is where we're actually going to have to go in some detail because there are a lot of different options for what can make up a complaint. First of all, you have the ability to draft a complaint on your own, or there are going to be a bunch of standardized forms. We're going to focus on the standardized forms today. Finally, every lawsuit has a fee to file it. If you are unable to pay the fee, you may qualify for a fee waiver. If you're on certain types of public assistance or have an income for your household below a certain amount, which is currently defined at approximately 125% of the federal poverty guideline, then the court will waive your filing fee. You might also have other circumstances such as extraordinary medical bills or other expenses that might allow the court to grant the waiver of this fee. If in your case you are asking under $10,000, your filing fee is going to be $180. Over $10,000 but under $25,000, your filing fee is $300. And over $25,000, it's $320. The forms you would use to ask for a fee waiver are the application for waiver of court fees and costs and the order on application for waiver of court fees and costs. Both of these forms are available online, and also you can get them from the court simply by asking for a fee waiver packet. Finally, if you're suing on a personal injury claim, you're going to want to prepare a statement of damages. Personal injury claims don't allow the amount of damages to be specified inside the complaint. The problem you have is if the other side ends up defaulting, you're limited to the amount of damages that you've notified them about. So the statement of damages form lets them know how much you're asking for in your case, and you typically will be serving it with the complaint. And finally, if your case is under $25,000, you might consider doing a case questionnaire, which is a form that you fill out that has a number of the common question sides in a small lawsuit might ask each other, and would then obligate the other side to answer the exact same questions. They do this in small cases as an option to simplify the amount of paperwork that needs to be exchanged back and forth. So the complaint. The purpose of the complaint is to let the other side know what you're suing them for and what specifically they did wrong. That's about it. You are not proving your case with the complaint. The complaint is not considered evidence. In fact, the court, unless they go to a default or unless it's raised at trial or arbitration that you didn't raise an issue in your complaint, will never go back and even look at your complaint. So a complaint has to do a few things. It has to identify the parties in the case and what their capacity is. Who are you suing? Are they individuals? Are they corporations? Are they business entities unknown? Whatever. They need to have at least one cause of action. Cause of action is legalese for a theory that the person suing for says they're entitled to get something under. That's about as simple as I can put it. If you don't have a reason you should get something, you don't have a lawsuit. Each of these causes of action, because only certain things are recoverable under the law, has to spell out specific allegations that form each element that must be eventually proven to win. So, for example, if you're suing under a contract, you have to allege that there was a contract, when it was entered, was it oral or written, who was a party to the contract, what did the contract say, when was the contract broken, who broke it, how did they break it, and what damages were incurred as a result. Now, some of the standardized forms will really help you out because if you fill them out properly, you'll have all of your elements. But if you start dealing with more complex issues, you're going to need to make sure that your hand-drafted pleadings list and deal with every element in a particular cause of action. And finally, your lawsuit must specify the relief you are requesting. If you want money, your lawsuit has to demand money. If you want some sort of an injunctive order, that somebody be ordered to do or not do something, well, your lawsuit needs to say that. The court can only give you something if you have asked for it. So if you fail to ask for something in your lawsuit, well, the court can't give it to you. Now, I had talked about standardized forms. Most of the forms that I've referred to already have a standardized form for them. So where can you get them? You can get them directly from the court or from the Judicial Council at www.saccourt.com. There's going to be a link on the screen that says Forms, or from www.courtinfo.ca.gov/forms. And that'll take you directly to the Judicial Council's form webpage, and it will have a drop-down menu for the different categories of forms, which will kind of help you interpret when we get to the forms. So let's talk about the first type of case we mentioned, breach of contract lawsuit. When you get to your complaint, you have two options. You can either do it on pleading paper, which is that 28-line paper with the 28 numbers on the side and the 2 lines on the left-hand side and the 1 line on the right-hand side that you can make inside of any modern word processor. A lot of attorneys do this because many of them will have templates already stored on their computer or in software that allows them to make these really quickly. Now, for the rest of us, most complaints dealing with contract can be done on standardized Judicial Council forms, and that's what I'm going to be showing you today. And there's a form called a complaint contract, which is in the pleading group. And then to that form, you're attaching your causes of action. And they have forms for breach of contract, common counts, which I'll talk to when I make a little analogy to Little House on the Prairie, fraud, and you can also attach additional causes of action, whether they're from other Judicial Council forms or attached on pleading paper. It's using the standardized forms is one of the simplest ways to make sure that you actually get everything that you need in your complaint. So I'm going to switch over and we're going to go through a sample form packet. Now, if you go ahead and find in your information packet sample pleading 1, breach of contract. Now, the first paper we talked about is the civil case cover sheet. This lets the court know what type of case you're going to be doing. Well, top of the form is something called the caption. You're going to get, by the end of the lawsuit, very good at filling out this caption. You'll notice the box says attorney or party without attorney. Most people never get past the word attorney and wonder what goes in that box. Unless you're representing someone else and you're an attorney, and I think I've got at least one in this room, you're going to be filling out your name and address. If you're represented by an attorney, it is your attorney's name and address. Where it says attorney for, if you're representing yourself, it's going to be in pro per. The box below is the street address of the court, and the case name is going to be usually the last name of the plaintiff versus the last name of the defendant, or the name of the business entity. This is called the short case name. It's a shorthand for what this case should be called. Where it says under civil case cover sheet, you're going to identify whether this case is an unlimited case asking over $25,000 or a limited case demanding under $25,000. This lets the court know what set of rules apply. If this is your first lawsuit, you're really not going to probably notice the difference, but there are a few subtle differences, especially during the discovery process between cases over $25,000 and under $25,000. You're not going to have a case number, judge, or department because you don't get any of this until you file. Actually, this court will only give you your case number. The big box underneath has a bunch of check marks as far as what type of case this is. Now, the biggest mistake on this form people will make is they check more than one box. Because the court is using this for statistical purposes, the way that they're tracking it, they only have the ability to track one of these boxes. So you're going to choose the one your case is most like. In this case, in the sample, we've done a breach of contract or warranty. Now, Kate, if we could go to the bottom of this form. Item 2. This case is or is not complex. If your case is a complex case, meaning it has many parties that are represented by counsel, thousands of pages of documents, things like that, you probably should be represented by an attorney. So I'm going to operate under the assumption you are not filing a complex litigation. And item 2, this case is not complex. If it were complex, you would check is, and you would explain why by checking the appropriate box. Next, remedies sought. Well, what are you asking for? Money, non-monetary, injunction or other relief, or punitive damages. You can check as many of those as apply. For the most part, on contracts, you're going to be seeking money. You might be seeking injunctive relief. You are almost never seeking punitive damages because for breaches of contract, breaking a contract doesn't necessarily make a person a bad person who needs to be punished. Number of causes of action. You're probably going to fill that out after you fill out the rest of your complaint. But I told you every lawsuit has to have at least one cause of action. Well, you're going to put whatever number applies there. And then finally, the case is not a class action lawsuit. Unless you are an attorney, you will never check the box is a class action lawsuit. Because a class action lawsuit requires you to represent other parties within the class. And the only person who can do that is an attorney. So there is never any time that a self-represented litigant will ever be filing a class action lawsuit. And then finally, you would date, print your name, and sign. The next form, if we go to the top, is called a summons. Purpose of the summons, once again, let them know they're being sued, tell them who's suing them, that they have 30 days to file a response with the court, name and address of the court, and who they should be sending their response to. Top box is your defendant. Now, one thing I wanted to point out is the language underneath Doug defendant's name, and does 1 through 10. Most common question I get asked when people see one of these forms is, what does 1 to 10 mean? Does that mean jail's involved? It's actually does. You've heard of John Doe and Jane Doe when you have an unknown person. Lawsuits can have unknown defendants. Now, why would you put any of them in your case? This case has 10 of them. Well, you may know who the other side is, but you have those extra defendants in there in case you've screwed up and you need to add somebody in. Because if you don't have them in, it's a rather complicated mess to amend your complaint and get it in later on. If you've got those unknown defendants in at the very beginning, if it turns out that you need to bring somebody else into the lawsuit, you just file a simple paper that says that the person formerly known as Doe number 1 is now John Smith, and then have John Smith served with the papers. If you go to the bottom, you'll see that it has the court name and address written in, as well as the plaintiff's name and address. If it were an attorney, it would be the attorney for the plaintiff. Finally, when these documents are given to the defendant, it should check whether they're being served as an individual or whether they're being sued under a fictitious name or whether they're being sued on behalf of a corporation, a defunct corporation, a partnership, a minor, etc. Let's move on. All right, the next form you've got in your packet is a complaint contract. Now you'll notice the very familiar caption at the top, which will have your name and address. You're the attorney for in pro per, court's information, the plaintiff and the defendant, and there are your DOE defendants again. Big trap. The plaintiff and the defendant, including all the DOE defendants, must match exactly between the summons and the complaint. There are many, many people who have had just even a letter off or have abbreviated the word company or corporation in one but not the other, who have found themselves in a whole world of annoyed when the other side fails to file an answer and they take it down to the court asking that judgment be entered, only to find that it can't be because the two don't match. Be sure to spend some extra time proofing your papers to make sure that where it says plaintiff and defendant, including the DOE defendants, that it matches the summons exactly. The designation plaintiff and defendant will remain constant during the entire case. The plaintiff is the name given to the person suing, in this case, you, and the defendant is the name of the person being sued. Has a box underneath that allows you to identify whether it's a complaint, an amended complaint, a cross complaint, or an amended cross complaint. I'm assuming this is your first paper that you're filing in the case, so it's going to be a complaint. And then finally, is the case going to be unlimited or limited? And if it's limited, is it over or under $10,000? That lets the court know how much to charge in filing fees. Paragraph 1, plaintiff's name. That would be you. Alleges the action against the defendant. And you're going to list any of your defendants in your case, as well as your DOE defendants. This pleading includes, including attachments, exhibits, consists of the following number of pages. When you're done with your entire thing, you're going to go back and fill that in with the number of pages. Now, I have not yet seen the court throw something out because somebody has failed to allege the number of pages, but it's something that you should make sure you have in there, because if the party later on asserts that other party asserts they didn't get the whole thing, one of the ways that they know if they get the entire packet is the number of pages that you've identified. All right. Item 3. Are you a competent adult? If you are, you just leave everything in item 3 blank. Now, there are spots to check if you're a corporation or an unincorporated entity. Let's say you're suing on behalf of a corporation or a partnership or an LLC. Those are the boxes that would be used, except for one thing. Corporations, LLCs, partnerships are legally persons. The only person who can represent another person in court is an attorney. So there is never any time, unless you are an attorney, that you will be identifying that the plaintiff is anything other than a natural person. Next, each defendant is a natural person in item 4, except if there are any defendants that you're naming that are corporations, unincorporated entities, public entities. Those would be, for example, the state of California, the county of Sacramento, or some division within, or other. You would identify them in paragraph 4. In this sample, it's just between two natural people. On the back side of the complaint, or on the next page, depending on whether you have a double-sided form, you're going to have the next allegation about DOE defendants. Who are these unknown defendants? You have the opportunity to specify who they are. Typically, you'll break them down the middle or however you see fit between ones that are agents or employees of the persons named and ones whose capacities are unknown. I typically, myself, end up breaking them in half most of the time, but if you really don't know who they are, you can just leave them all as persons whose capacities are unknown. Next, let's go on to 5. If this is a case against a governmental entity or there's some other claims requirement that is necessary before you can bring your lawsuit, you would be checking Item 5, plaintiff is required to comply with a claim statute, and hopefully you have complied, and you'll be checking box A. For most types of contracts, there's not a claim statute, especially if you're just talking about contracts between private individuals. All right, paragraph 6. Most of the time for the things you will be suing for don't apply. However, these are questions, are these installment contracts on the sales, are they installment contracts for the sales of goods, contract installments for automobile sales, etc. Look up the code sections if you think you might fall into there, and it'll spell out exactly which one you're referring to. I'm going to assume they don't apply because I'm going to guess most of you are probably not filing this on behalf of anybody that's entering these contracts. But if you are, we can talk about it more in depth later on. You have to say why this is the right court to sue in. And you would check all the boxes that apply. Was the contract entered here? Did the defendant live here when the contract was entered? Does the defendant live here now? Was the contract to be performed here, etc.? Check as many of those boxes as apply. Finally, the complaint form, and one of the biggest mistakes I see when using this form is that somebody doesn't attach a single thing to this. This form cannot stand on its own. You must attach your causes of action to it. And this just lets the other side know what causes of action that you're attaching. And we're attaching to this one cause of action for breach of contract, cause of action for common counts, and if you were attaching other ones, you would check other and you would list them. 10 is the relief you're requesting. You check the boxes that apply, and you enter the amount of damages under A. If you're doing interest, prejudgment interest, it's typically going to be at the rate of 10% from the date of the breach of contract to the date of judgment. Attorney fees are generally not recoverable unless there is a clause in the contract that allows attorney's fees to be recoverable, or if there is a statute that allows attorney's fees to be recovered for a particular type of case. If you're an individual suing another individual, most of the time these fees are not going to be recoverable unless it's in that contract. If they were recoverable, you would check the appropriate box to say attorney's fees, and then either the amount that's specified in the contract or how it's going to be calculated or according to proof. And then if there's any other relief you're requesting, you put it in item D. When you're done, you would date, print your name, and sign, unless any particular part of your complaint is stated only on information and belief, in which case you'd check box 11 and specify which parts of it were on information and belief. All right. The next form that you have is the standard judicial counsel form for a breach of contract cause of action. The first thing you'll notice is at the top where it says short title, there's a spot to put the name of the parties, just like you did on the civil case cover sheet. Reason you're doing that is in case the court clerk accidentally drops the papers. They want to be able to know what document it goes back into, or if it gets somehow otherwise shuffled up. You want to make sure your papers get back into your correct case. It makes life easier for everyone. I've never seen a document rejected because it isn't there, but on the other hand, it's of common courtesy for everyone involved in processing your paper, and also if you have more than one case going on yourself, to have that information there. Before the cause of action, there's a blank. That's for the number of the cause of action. First cause of action, second cause of action, third cause of action. It gives the other side something to refer to if they, in your case, what you're alleging, because you might have, for example, multiple breaches of contract alleged. Well, are you talking about the contract in the first cause of action or the one in the second cause? You would identify whether you're attaching it to a complaint or a cross-complaint. BC1, plaintiff, that's your name. And then you allege that on or about a particular date, there was a written contract or an oral contract entered into, and who the parties of to the contract were. Now you will typically attach as an exhibit a copy of the contract if it's written, or you will specify the essential terms of the agreement and then check are either as follows and define it in that blank, or are stated in attachment BC1. And you would attach a page called BC1 where you would spell out what was in that contract. From a simplicity standpoint, if you have a written contract, 9 times out of 10 it's easier to just attach the written contract. There's no ambiguity in there, and it's just one checkbox. Little extra photocopying, but a lot less typing. BC2, on or about what date was the contract broken? And you're going to put the date that it was broken, and then you're either going to identify the facts behind the breaking of the contract in an attachment called attachment BC2, or you're going to check the following acts and spell out what they did wrong. So in this case, there was a contract to pay a certain amount. Doug defendant failed on June 15, 2007 to make his monthly payment of $1,067.96 and has failed to give any additional payment despite demand. Straightforward. BC5 would be if you were entitled under the contract to attorney's fees or under statute, you would specify it there. And then BC6 would be any other allegations pertaining to it. Now, if you recall, about 25-30 minutes ago, I went through the list of things you had to show to do a breach of contract. You'll probably notice that that form covered all of them. If you use this attachment form, it will walk you through most of the elements that you need. Next one would be cause of action, common counts. Notice it's labeled second cause of action. Now, what the heck is a common count? I get that question all the time, so I always like to refer people to Little House on the Prairie. Now, if you ever recall watching an episode of Little House on the Prairie, you'd notice that the Ingalls girls every now and again would go into town and there was a general store. Now, for some reason, there's always another customer in the general store. I guess it's more interesting cinematography that way. Well, one thing you never ever saw that other customer do is reach into their pocket and shell out cash. Well, imagine the shopkeeper doesn't pay, or the shopkeeper doesn't get paid by that customer. He goes down to the court and files his lawsuit. And he brings out his ledger book that he wrote down, the customer's transaction while they were there. And he brings in the statements that he's been sending. He brings in his list showing the value of the goods that were taken. And if the court is strictly interpreting contract law, they're going to look at him and say, well, gee, all that paper is very nice, but where's the proof of the defendant's intent? Where's the defendant's signature? There's no contract. You lose. Well, a long time ago, the courts recognized that certain common types of business transactions can be sued upon as if they are contracts, even though they're not quite, and they've called these common counts. The first two are not alleged in this because it's a simple contract between individuals, but an open book account is that ledger book that shopkeeper fills out. If there's activity in the ledger book, every customer gets their own page and doesn't get mixed in with anyone else's. Nowadays it's electronic. If there's activity on the account within the last 4 years and there's still an amount owed, it's an open book account. They can sue within 4 years of the last activity. Account stated. The business sends out monthly statements to a person. The statements have a way to challenge the statements if they're not, if there are any disputes. Nobody disputes it, therefore it's agreed that that amount's owed. And that's what the account stated it is. Well, in this case, They're just going on what other things, could you be sued under? Well, for money that you lend out, for money that's paid to others at someone's request, a few things like that. Typically, you're going to have two possibilities. Either it's written or not written, in which case it's either 2 years or 4 years. In this case, it's for money lent by the plaintiff to the defendant at the defendant's request. And then finally, at the bottom in CC2, there's a spot to allege the amount of damages that's owed, interest at the rate of 10% from the date it was breached. 10%, by the way, the reason I'm going back to this number is in California statute and the California Constitution, they've set 10% currently as the legal rate of interest. Interest over 10% is generally not recoverable in California outside of a few specific exceptions. Now you're probably wondering, well, how's my credit card charging me so much interest? And that's because they're governed under federal law, and that has a different set of regulations that apply. Now, we had said that there was a contract attached as Exhibit A, so the next page you're going to have will identify that you're attaching an exhibit, and then after that, here's a copy of the contract. Pretty straightforward. One of the questions I get about contracts is whether or not something is a contract because, whether it looks like a contract. And contracts can be formal, they can be written in any typeface, they can be handwritten. You can have a contract written on a napkin of a pizza parlor. The only thing that makes a contract is there has to be an agreement between two parties where each party is agreeing to give or do something. And then if it's written, it's signed by each party. And that's basically it. There may be other defenses, but contract need not be fancy, and indeed this one isn't. All right, one last form that I think I had told you about was whether it was the fraud cause of action. And I'm going to ask Kate if we have one of those hiding inside the packet.
I don't see one, I'm sorry.
It's okay. I have an extra one here just in case. Actually, could you grab me one of those papers in that envelope? I just wanted to take a moment to talk to you about fraud. Fraud is one of the most misunderstood contractual causes of action ever. And the form that they have created to simplify the process for you at the Judicial Council is practically useless. Well, the contract cause of action walks you through every element that you need to allege, and just having the basic information in there is enough because the court is obligated to liberally interpret most causes of action. The fraud is pretty skeletal. It doesn't give you a whole lot to go with, and the court does not liberally construe your cause of action for fraud. I told you breaching a contract doesn't make a person a bad person. Well, when you're alleging that somebody has committed fraud, in addition to the legal elements, you're saying something bad about that person's character. And because you're imputing that person's character, the court wants to know with specificity who did what and exactly what did they do or say. There are 3 theories of fraud, and this is why the form is also pretty useless, is because all 3 of these theories are listed on the same form, and although you typically only use one within each cause of action. And the reason that you typically do a separate fraud form for each theory that you're alleging it under is in case you've screwed up and they throw out one of your causes of action. If it's all in the same cause of action, it all gets thrown out. So what you are probably used to thinking of fraud probably isn't legally fraud. Fraud is based on the idea that somebody has, thank you, that somebody has either made a, may I have the first page, please?
First page.
Yes, the one right before that one. And we'll go through it really quickly. All right, that somebody has either made an intentional or negligent representation about a material fact with the intention that was false, with the intention that you rely on it to induce you to give something or otherwise be harmed that you wouldn't have otherwise done. Alternatively, it's that, if you could go to the bottom, that they conceal a fact that they are required to disclose, or by specifically stating other facts that they are designed to mislead you, that with the intention of causing you to rely on it, and that you do reasonably rely on it, and it causes you harm. And finally, negligent or promise without intent to perform. They promise to do something, but at the time they promise it, they have no intention of doing it. They intend you to rely on that promise, you do, and are harmed. That's basically it. Welcome back, everyone. Just a little bit of housekeeping that was pointed out to me over the break. On the, I believe it's the 9th slide in your handout under Common Statutes of Limitations, due to the miracle of cut and paste, it was pointed out that I've got the written contract and property damage statute of limitations reversed. The information I gave as far as the written contract being 4 years and property damage being 3 years is correct, not what's written on that page. So you'll want to make a change to that, and we'll be sure that if we have a slide presentation for anyone viewing this on the web, that we'll have those numbers reversed. All right. Well, this next part, we're actually going to be going through 3 times as many forms, but fortunately they're a little bit faster. It's going to be on the basic personal injury complaint. Fortunately, there's a lot less to write on some of these, so we'll hopefully do it quickly. Just like you could in a contract, you can hand draft your own personal injury complaint inside of any word processor on pleading paper. Now, for most of the things that you will be suing for, however, there are some standardized forms that might make things a little bit easier for you, and we're going to go over those. The typical ones is the basic complaint personal injury property damage or wrongful death. And then, just like on the complaint contract, where there is the cause of action form for each of the ones you might attach. There's one for motor vehicle accidents, general negligence, intentional torts, premises liability, and products liability. And you can also attach other things. Finally, in some cases, there are reasons that a person in one of these cases might be deserving of other damages, punitive damages to punish them awarded, and they have a form called the optional exemplary, or called the exemplary damages attachment, that will allow you to allege those facts if you want to ask the court for these additional punitive damages or exemplary damages. Now let's go ahead over to the camera. Now in your next packet, let's start out with the summons. We'll go through it just the first time. You'll notice this first one in the complaint, I believe it's number 2 in your handouts, is a sample complaint for a simple automobile accident. I love complaints for automobile accidents because they're probably the fastest one to fill out. There's almost nothing to them. The forms are pretty complete. I guess there are enough automobile accidents that the Judicial Council decided to make it really, really easy to file the paperwork. Well, we start out with a civil case cover sheet, which is going to be filled out pretty much exactly like it was before. You know, whether your name, address of the court, case name, whether it's limited or unlimited, and then finally, there's a nice little checkbox here for an automobile accident, for an auto tort. And then down at the bottom, the case, and I've got, well, crud, the wrong box there. This case is not complex under item 2. We'll once again change that, asking for monetary relief, causes of action, 1, and it's not a class action lawsuit. Let's move on to the actual summons. Summons is filled out exactly the same way. Now, DOE defendants. Automobile accidents are one of the most likely times you will actually ever use a DOE defendant. You're in an automobile accident, you're suing the other driver. A lot of the times you find out that maybe somebody else owns the vehicle. They're going to be a DOE defendant if you don't know who they are at the time you file your lawsuit. So if you're filing an automobile accident, you'll almost certainly want to leave in your DOE defendants in case you need to add somebody else in or if somebody else is somehow responsible for the accident. The complaint itself by now should be starting to get relatively self-explanatory. The caption works exactly the same way with your name and address, attorney for if you're representing yourself, in pro per. The plaintiff and the defendant, just like you had before, and they're your DOE defendants. There's a box to check if it's a motor vehicle accident, and you indicate whether you're asking for property damage or personal injury or both. If you move on down, item 1, plaintiff is, and then your name, is alleging against the defendant. You can also add your DOE defendants in there. This pleading consists of the following number of pages. Each plaintiff is a competent adult. We already discussed that you can only file on behalf of yourself unless you're an attorney, so you're not going to have any corporations or LLCs in there. And then we go on to the next page. Each defendant is a natural person. If they're not, you check the appropriate boxes to indicate what they are. Are they a corporation? Are they an LLC? Are they a partnership? The instances where you would typically get one of those is if you've been in a car accident with a commercial vehicle being driven by an employee of a business entity. Item 6, we talk about the DOE defendants. Now, either you can specify you don't know who they are, or are the DOE defendants agents or employees, or some combination of the two. Item 8, why are you suing in this county? Either the defendant lives here, or the accident took place here, or the business or corporation that's a defendant is here. That simple. Claim statutes, once again, if a claim statute applies to your causes of action, you would check the necessary boxes in 9 to indicate whether one applies, and if it does, whether you've complied with the claim requirement. Item 10, what causes of action are you attaching? Since this is a simple automobile accident, we're just attaching 1 in this case. What type of damages have been experienced? Item 11, in this case, the plaintiff is claiming wage loss, loss of use of the property, hospital and medical bills, general damages, and property damages. All right. Item 12, you would only use in the case of a wrongful death. 13, the relief sought is in this complaint is within the jurisdiction of the court. Now there's a nice big space around that, but it's actually just a standalone sentence. You can only ask for what the court can give, and that's alleging that what you're asking for the court can give. 14, what type of damages are you asking for? For the most part, in a car accident, you're only going to get compensatory damages. Car accidents happen. If you're injured in a car accident, your property is damaged in a car accident, For the most part, you get, the other party is at fault, you are entitled to recover the amount of the damage to your vehicle or person to put you back where you would have been if it hadn't happened. Yeah, we all get in car accidents. We're not bad people. Now, on the other hand, if you're being hit by somebody who's driving down the wrong side of the freeway after drinking a couple of six-packs, and then you might have a case for punitive damages because they're doing something that's so outrageously bad that no reasonable person should be doing it. But for the most part, car accidents, straight compensatory damages. Anytime you are if you were requesting only property damage, you could indicate the amount of damages that you're requesting. But anytime that there's a personal injury claim thrown in, you do not get to specify on the complaint the amount of damages that are sought. It's always going to be according to proof. Finally, at the very end, place to date, print your name, and sign. So let's see the motor vehicle cause of action, which in this one is the only one attached. First cause of action, motor vehicle. First thing you're going to notice about this form is there's almost nothing to it. There are a lot of car accident cases that are filed, and this has all the elements that you need. All right, you identify, is it attached to a complaint? Who's the plaintiff? That would be you. On a particular date, at a particular place, plaintiff alleges that the defendant was negligent and that these were the causes of injuries and damages. Okay, that's very skeletal. You just need a date and where it took place. MV2, who are the defendants? All right, the driver of the A, who is driving the motor vehicle? The name of the person, the dose if it turns out that that's not actually the driver. Who was employing the person? If you know this, you put that in there because they're already named as a defendant. If you don't, you're going to have the checkbox and your DOE defendants. Who owned the vehicle? Well, who you believe the owner is, and the DOE defendants if it turns out that somebody is wrong. Item D, who entrusted that vehicle to the driver? Well, if you know that information, you once again put that in there, and you'll check the box for your DOE defendants in case it's somebody you don't know about. And then finally, who were agents or employees of the other defendants? It's probably going to be the DOE defendants, unless you know that somebody was acting as an agent employee for one of the known defendants, in which case you'd list them in there. If you've got any other reason that anybody is liable, you put that in box F. That's actually it. There's nothing. That is a complete motor vehicle personal injury and property damage claim. On a good day with form software, one of those takes me about 5 minutes at most. So it makes it very easy to file. This takes longer. The statement of damages. If you recall, you checked on the complaint that the damages were in an amount according to proof. Well, let's say that the person doesn't end up answering their lawsuit and you want to get a judgment from the court. You're generally limited to the amount of damages that you've asked for and that you put the other side on notice that you're asking for. Since you can't put the damages on the complaint, how do they know what you're asking for? This form, the statement of damages. You indicate, you just check the boxes for the appropriate types of damages that you're asking for and how much you are asking for under each type of damage. In this case, they've listed the maximum pain and suffering amount that's statutorily set at $250,000. They haven't listed any of the other ones for emotional distress, loss of consortium, loss of society and companionship, which would only apply in wrongful death cases, and other. Now, if you're not familiar with the term loss of consortium, I should probably just explain it because everybody ends up asking me what that is. It's essentially the inability, or it's the loss of how shall I euphemistically put it, marital relations following an injury. Special damages. This is also confusing to people. They're like, why is it special damages? This is what I've suffered. It's your medical expenses. Your medical expenses that you're going to experience in the future. Your income that you've lost as a result of the injury or the other damage. Loss of future earning capacity. Has the injury in some way altered your ability to earn money in the future? Property damage. If it's a wrongful death case, of course, it's funeral expenses, etc., but we're not going to deal with that here. One thing you should know. When you're claiming your medical expenses, the most common mistake I see pro-pers make is they will list only their co-pays that they're paying out. So they'll get they'll know that they've been to the doctor 10 times, that they've spent $10 on co-pays and put out $100. You want to actually list the full list amount of the damages that you've received, because your insurance company that provided the medical services has a lien against your claim potentially for any amount that you recover for medical damages, because that's what they paid out. So you would still get your co-pays and so on back, but the people who actually paid for your insurance or for your medical treatment are entitled to get, if it's recovered, the amount that they paid out. The other thing that is very difficult for people to understand or predict is their future medical expenses and their loss of earnings or their loss of future earnings. These are rather difficult subjects. If your case ever goes to trial, the way that these are typically proven is by putting on expert witnesses that are experts in injuries, careers, etc., who typically who deal with actuarial tables and so on to figure out things such as, what was your career trajectory before the accident? What is your career trajectory now? What is the difference between the two, and how much would you have earned more over the course of your lifetime? How has the injury restricted your ability to work? You as an individual will probably not have all of this information available to you. There are a number of books that are available at the law library that deal with damages to help you estimate it in much the same way that an insurance company might estimate it. But if this is your first lawsuit, you're not going to probably know this information. One thing you should know, however, is since you are limited at default or even at trial for the amount of damages that you have requested, if you underestimate your damages on this form, you have set arbitrarily the upper limit that you can recover. So while your estimate should be rooted somewhere in reality, it should also be at the upper end of that reality if you don't want to limit your options. Finally, at the bottom, spot to date, print your name, and sign. And if you're asking for punitive damages, how much you're asking to reserve is your maximum amount of punitive damages that you're asking for. All right. We've got our next complaint type. We'll skip over the summons and civil case cover sheet. Premises liability, another form that they make relatively easy. Premises liability is where you are, well, on someone else's premises and you're injured. These range from the stereotypical slip and fall to walking down the street, having a scaffolding land on you. Injuries vary greatly, but the form makes it easy to plead. By now you should already know how to fill in the caption with all of the required information. Under the complaint, you get to indicate it's a premises liability case, and whether you're asking for personal injury or property damage or both, wrongful death if it's applicable. I'm going to operate under the assumption that pro per you're not going to be requesting your own wrongful death case, although I have actually seen someone file that, but that's a story for another date. But you might be requesting one on behalf of a loved one or family member. Everything is going to be exactly the same on the complaint personal injury until you get to the next pages. Okay, let's keep going. Where you indicate what causes of action are attached. Now, since you can check as many of these as apply, I've simplified these cases a little bit intentionally to just focus on one of the causes of action, but there are many cases where you might have more than one attached. In this case, they've got the form for premises liability, so that box is checked. The damages in this case are going to be different because there's no loss of property that's alleged. And then the whole rest of this form is the same. So let's go ahead and cut over to the premises liability cause of action form. You'll notice that this is only slightly more complicated than the form for personal injury. For motor vehicle accidents. First cause of action attached to a complaint, plaintiff's name alleges that on a particular date, and you specify the date, they were injured on the following premises and the fashion and description of the places of injury. All right. In this case, the plaintiff was a customer at the defendant's business and was shopping. Shelf toppled, falling on top of the plaintiff, pinning him to the ground and causing injury. Premises L2. What theories are you entitled to recover under? They put several of them right onto the same form. Negligence. All right. All you have to do is check the box and indicate who was negligent in owning, maintaining, or managing the premises. And then you throw in your DOE defendants in case it's actually owned, managed, or maintained by someone unknown to you. Count 2, willful failure to warn. As a general rule, if you own or maintain a premises, you have a duty to warn those people who are there on the premises of dangerous conditions. If you have a shop and you've got a large pit in the floor, you need to put up some sort of warning so that people don't walk into it. It's pretty straightforward common sense. Well, this is what this is alleging, is that they know about it and they willfully failed to warn against the condition, and you were injured as a result. Count 3, dangerous condition on public property. This would be if there is public property outside that the person was required to maintain or otherwise was responsible for. That's going to be your sidewalk accident. And then if there are other allegations against other defendants, it would be specified in premises liability 5. There were almost no words written on this page other than the brief description of the liability at the very top. Just like the motor vehicle accident, this whole complaint is about a 6-minute form from start to finish if you're reasonably fast at it. Now, of course, with anything, don't let this fool you. Actually proving it's another matter, but getting the paperwork filed, that's easy. Now let's move on to our final complaint. Products liability. The form, easy. Proving the case, often difficult. Complaint is going to work exactly the same. Only thing that I'm going to point out for you here is, in this case, we've named a couple of corporations as defendants. So when we go to the back of the page, you'll see that it's indicated that the defendants, Super Happy Inc., is a corporation and Mega Big Mart is a corporation. We have more DOE defendants listed in here. And other than that, on the final page, since we're simplifying things, we're just going to show that a products liability cause of action is attached. So let's skip to that cause of action. All right. First cause of action, products liability. All right. Plaintiff, their name, was injured on a particular date by what product? What product were you using that caused injury? All right. In this case, the Super Happy Widget Weaver model WW501, or whatever it happens to be. All right. The next one is, how is this product being used? Now, if you use a product in a completely unintended and unreasonable way, it's your own fault that you're injured. Just because you're injured by a product doesn't mean you are entitled to recover for it. So if you decide that you want to use your car to, maybe swat a fly lying against the wall at 80 miles per hour and you intentionally do it, you're responsible for that. But if you use the product in the way that it's intended to be used and it causes you injury due to a defect, well, that's recoverable. Likewise, if you use a product in a way that it can be reasonably anticipated that you would use the product, it's also recoverable. The example I like to use for the latter one, lawn darts. Does everyone remember what lawn darts are? They're perhaps one of the most wonderfully dangerous toys I remember playing with. They're a stick with a fin on it and a heavy weight on one end with a long metal spike about this long. And the idea is that you would take this lawn dart and you would throw it through the air and try to hit a target, maybe 10, 20 feet away. Well, can anybody anticipate what kids are likely to actually do with these things? Straight up, and when a 1-pound toy with a metal spike that long hits you in the head, the results are not pretty. This is why they no longer manufacture lawn darts in that shape or form, is because they were incredibly dangerous when they were used in a way that somebody with any common sense would realize that a kid would use them, despite the warning labels. So, that's the second, is used in a manner that was reasonably foreseeable by the defendants as involving a substantial danger not readily apparent. Adequate warnings of the danger were not given. And in the case of lawn darts, if it were being told to you and me, it's reasonable that we would not use the lawn darts in that manner. We have more sense in that. But these were being marketed at kids. So despite the warnings given, you can't expect a 5-year-old to know that despite what you tell them, they're going to run with scissors. All right. Plaintiff's injury was the legal proximate result of the following. Count 1, strict liability of the following defendants who manufactured or assembled the product. Who manufactured or designed the product? You list them there, and then the DOE defendants if it turns out that you're wrong and it's someone else. Who designed and manufactured the components of the product? You're probably going to have the DOEs there, because when you get a product, you don't know where those components came from. You don't know where they were assembled from at the factory, but you can almost certainly be sure that when this thing ever goes to court, if it does, that manufacturer is going to be hauling in all of their parts suppliers that could have possibly caused the damage, and you want to be sure that you can recover against them as well. Count 2, who sold the product to the public? That's typically going to be the retailer. Count 2, negligence. All right, who owed a duty to the plaintiff? And you indicate, to not sell this really dangerous product. And you list the named defendants and probably your DOEs. Count 3, breach of warranty of the following defendants. All right, who issued the warranty on the product? And was it going to be an express warranty? Did they provide an express warranty as to that this product is not defective? If they did, you've got an express warranty and you indicate the person who indicated it. If there's an implied warranty, because it's assumed that most products marketed for a particular purpose are suitable for that purpose, you would instead check the who breached the implied warranty. One last thing is if it's an express warranty, you have to indicate whether it's written or oral, because a warranty is essentially a contract. All right, and if there's any other reason that somebody should be liable, you put them in L7 and why. And with the end of that one-page form, you now have a full products liability complaint. Not much to it. So let's go back to the slides. And I'm going to go back a couple of pages in your handout as I want to talk to you about a couple of other things. Verification. There is not a standard form for a verification. A verification is attached to your complaint. It is optional, and it is a statement that says the following: I, the name of the person declaring it, and if it's in this case you, who's a party to the case, am the plaintiff to this action. I have read the foregoing complaint contract or complaint personal injury or whatever document it is that's being sworn to, and am familiar with its contents. I have personal knowledge of the matters asserted, and I declare that they are true to the best of my knowledge, except for those matters that are stated on information and belief, as to which I believe those to be true. And then you write, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Date it, print it, sign it. I believe in the whole packet I have a sample verification. If not, one will be posted on the website along with this presentation later on. The effect of verifying your complaint is that if you're asking more than $1,000 in your complaint, the defendant must answer and verify and specifically identify what is false in your complaint and must swear that their answer is true. This is called submitting a verified answer. The reason you would want them to do that, or at least consider this as a possibility, is if you expect that they're likely to answer but don't know what they're doing, for example, or they don't have any good defenses, and they verify that everything in your complaint is true and don't assert any real defenses, you can then file something called a motion for judgment on the pleadings later on, which would say there were no defenses raised and all the facts were agreed upon and I should win. Or also to pin them down to one particular set of facts, because once they swear that something is true in their answer, they can't later on deny it. So there are some good strategic reasons to verify your complaint. On the other hand, if it's just going to be something that's going to need to be proven no matter what, or you don't have the ability to know everything for certain, then you would, you could forego that step. Your next step is filing your lawsuit in court. You now have a bunch of papers. The civil case cover sheet is its own document. The summons is its own document. The complaint, along with all the causes of action, is a separate document. You're going to want to take each of these and make 3 copies of it. That's the maximum that the court staff will accept when filing. And you take the original, 2-hole punch it, place it at the top of each pile for each form, and put the 3 remaining copies underneath it. You would do the same thing with your fee waiver packet, your fee waiver application, your order on your fee waiver as well if you're filing one. Once you have your original and 3 copies of all of your documents, you would file them in room 102 of the downtown courthouse if you're filing in Sacramento. The court clerk, assuming you've got everything put together right, will take the original document and keep it for the court file, and may possibly retain an additional copy of the document depending on the practice of that particular clerk or the practice of the court at that time, and will return any remaining copies to you with a stamp on it. That stamp will say that it's endorsed by the court, and that is your proof that it has been filed. Now, I'm not going to say that the court ever loses documents. They are merely occasionally misplaced, and given the number of documents that pass through the court, it's exceptionally rare. Nonetheless, there are instances where something may get placed into the wrong file or scanned incorrectly, in which case having that stamped copy of your own is your proof that it was submitted, and you will want to be able to produce that later on if there's any dispute as to whether or not the document was provided. Plus, it's just good sense to retain every document that you get. 102, in the line that says civil law filing. Depending on the time of day that you go there, it may look like you're waiting for something at Disneyland, but once you get to the front of the line, ride's kind of a dud. But they are efficient, and they get you your papers back. What you will then do is thank you. You will need to serve the defendant. What do I mean by serving the defendant? Whole purpose of the concept of service is fairness. The idea is if you sue somebody, the defendant needs to know they're being sued. The way that they want the defendant to know this at the very beginning is they want somebody to walk up to this person and hand him a copy of the papers. And they're a little bit particular over how this is done and who does it. The defendant must be served by someone over the age of 18 who is not a party to the case. You cannot serve your own papers. You can have a friend do it, you can have a registered process server do it, you can have the sheriff do it. We have a little booklet in your handout called Who Should Serve My Papers that gives the contact information for the service process, for the Sheriff's Civil Division, as well as information on finding a process server. What they get served with is pretty much everything that you filed with the court minus your fee waiver, because that's not their business, plus some additional documents that the court will give you when you file, a packet of local forms, as well as an order either for case, telling about department assignment, case management, and possibly an order to file something called a case management statement later on. Once all of this is handed to that person, the person who hands it to him fills out a document called a proof of service of summons. Now, the proof of service of summons, the name of the party served on it must match the summons and complaint and summons exactly. That's another pitfall where I'll see somebody sue John W. Smith. They will have on their summons John W. Smith, and then their proof of service will say, I served the party known as John Smith. It's not the same. All of them need to ultimately match. The defendant's time to answer starts from the date the papers are handed to them. Thank you. Whoops, helps if I hit the right button, doesn't it? List of everything that you need to serve. That's everything that you file with the court plus everything they give you back minus your fee waiver. Each court can have different local forms that they want you to serve. So if you're not doing this in Sacramento County, you might want to ask the clerk if there are any additional local forms that need to be served in their court. All right, individual defendants, they're easy. You just have the person serve them directly. If you're suing a corporation or an LLC, you typically serve the person listed as their agent for process of service. If you go to the Secretary of State's website, and I've got the direct link listed on the screen, that's the Secretary of State's business portal. You can look up any LLC or corporation that's licensed to do business in California, and that will list on that page who their agent for process of service is. This is the person, because corporations, although they're legally persons, they don't have a physical body for you to give them the papers. but they all designate somebody who is there to receive the papers, and that's who gets them. Other entities may require some additional research. There's a short book. This is not it, but it looks very similar to it with the blue cover. Handling Service of Process. These little blue books put out by CEB, they're like Cliff's Notes for attorneys and paralegals. And they have one called Handling Process of Service that's particularly useful in figuring out who you should serve. All right. What goes on in personal service? It's really very easy. The person who's serving the papers walks up to the person. If they don't know who the person is, verifies who it is, and hands them the papers. That's about it. It's nice for them to tell them, that they're legal papers and what they are. If the person is cooperative, it's really simple. Hey, are you John Smith? Yeah, hi, I have some legal papers for you. Oh, gee, thanks. Service is complete after the proof of service is done. Or service is complete and then the person serving does the proof of service. Well, common questions I get. Well, doesn't the person have to sign anything? No. The important thing is that the papers get given to the person. Well, what if the person gives them back? Doesn't matter. Hi, I have some legal papers for you. Gee, thanks, I don't want them. All right, they're very important. I'm just going to leave them with you right here and leave them in their vicinity and control. Service is complete. What if the person won't accept them? The important thing, once again, is that face-to-face contact and letting them know what the papers are, that they're legal papers, that they're being sued, and leave it in their vicinity and control. I'm not taking those very well. I'm just going to set them right here on your desk for you. They're very important. They're legal papers. Have a good day. Service is complete. Here's where we get a little bit tricky. What if the person doesn't open up the screen door or the gate? That breaks that face-to-face contact. Although I've never seen the issue ultimately come up in litigation, I'm sure it's out there somewhere, that it's going to be a factual question at what point is that contact broken? At what point is the service not valid? Sometimes a person can't be sued personally. In those cases, you can do something called substituted service. That's serving another person, either a co-resident in the household where the person resides, or the person in charge of the business where the person is working. The person apparently in charge. Substituted service is not as good. It's done only when you can't otherwise serve the person. It requires the declaration of diligence that the person was attempted to be served upon at least 3 different times on 3 different dates on 3 different times of day. And at which point it was left with the person who was apparently in charge, and then the name and description of that person. If you're representing yourself and you're having a friend do your service, anecdotally I would say there's about a 90 to 95% chance that your person is going to do the substituted service wrong. You should probably rely on a process server if you're doing substituted service, unless your friend really knows what they're doing. Substituted service is also oftentimes easier for a person to set aside, because oftentimes you'll end up having somebody leave a document with somebody at a house, and it'll turn out that the person's just taking the papers and the person doesn't actually live there. And that's a problem. So substituted service, second best. Always do personal service if at all possible. Whoops. May I back up, please?
Sure.
Thank you. Finally, other methods of service may be available. Once again, if you cannot get it served through either personal service or substituted service, I would strongly, strongly recommend using a process server just because it's much too easy to screw up your service. Service starts the time for the defendant to answer. They have 30 days from that moment to file an answer, 40 days if it's done by substituted service. At that point, they will do one of three things. They will answer within that time, which then starts the lawsuit. They will file a demur to your complaint, meaning they're procedurally claiming your complaint is defective in some way and that even if everything in your complaint is true, you would still lose. Or they don't answer. If they don't answer, that's the easiest because you can then ask the court to enter something called default, which says that if they don't bother to answer, I'm asking that they be stopped from answering and ask for something called a default judgment if they're the last defendant left in the case, which would be to ask the court to enter a judgment based on the fact that they didn't enter or didn't answer. Last thing I want to leave you with is we've talked about filing a lawsuit. You should know that this is only the first step of many in the lawsuit process. I normally describe how a lawsuit works like a football game and have a handout inside of your packet that draws the analogy. Filing and serving the lawsuit is like the home team running out there onto the field. It starts the game from their standpoint and they're ready to play, but you still have the entire rest of the game left. If you want to have any chance of winning your case, you're going to want to do some further research. There are a number of books that Kate is going to tell you about and that will help you prepare for handling your case. I'm running out of time as far as this video is concerned, so I'm going to let her give her presentation and then we'll take any questions you might have.
I'm going to go over a little bit about what we have available in the law library just to get you familiar with it. And I want to emphasize that we have a librarian on staff at the reference desk anytime we're open. So you're always welcome to ask us for help. Since I'm going to go over this really quickly, you may still have questions, and that's what we're there for. The law library is open to the public. It's the building that we're in right now if you haven't been here before. The entrance is one floor down from here. We're funded by filing fees, so anytime someone puts in a lawsuit and pays one of those $180 to $320 fees that Eric mentioned, we get a little chunk of it. We're not actually supported by taxes. Can you do that?
Sure. Hit the button again. There we go.
Thanks. The library has a couple of different types of resources that I'm going to talk about briefly, and they have different purposes. One of the types of resources that we have is called primary resources. Primary resources are the actual law itself, and they're composed of statutes that the legislature passes, cases that courts have decided in the past, and regulations that the state agencies create. And those three things are the law, and they're interpreted a little differently and used in different situations, so it may end up that you need to research one or all of those for your case. Secondary sources are sources that are actually probably more useful in putting your case together once you've got a grasp on what issues, what laws you need to look at. The secondary sources will have a lot of resources for you that will help you do samples, or if you don't know yet what law is applicable to your case, they're a good place to start researching. You can look things up by topic and it'll tell you, if this is a breach of contract, here are the civil codes that apply to it. We have those available as books, and many of them we have available as electronic resources. We have a bunch of different databases. One of the most popular is called Westlaw. Westlaw is a subscription database. It's actually one of our single biggest expenses every year. It's quite expensive, and it's available to the public. There's no charge for using the database. If you need to print out, it's 15 cents a page, but that's the only cost associated with it. We have a few other databases that are also available to the public that serve sort of different purposes. Westlaw is really good for researching cases, also for statutes and regulations, and it does have some of that secondary material, so you can find sample forms or articles on topics that might help you get started. On Law, oh, can you go back? Thanks. On Law, LexisNexis CD, U.S. court forms are all things that have samples or forms that you can use to fill out. And On Law and the LexisNexis CD also have some topical articles that will help you do your initial research. Okay, thanks. One of the most important things at the library, as I said, is the librarians. We have someone on staff at the reference desk whenever we're open. And we're always happy to help. Sometimes we get a little busy, so we'll do what we can. It's important to recognize that we're not lawyers. We can't give you legal advice. We can help you find answers, but we can't tell you, for example, should I file this lawsuit? What should I do next? This person responded with a demur. What do I, do I have a good case or not? We can't answer any of that kind of question, but we can say, well, here's a book to read about your case and see whether you can respond to that demur in a way that keeps your case alive. We have some specific ones that we often refer people to when they're working on their own lawsuit. Win Your Lawsuit. Let's see if I can do this. Win Your Lawsuit is a book from a company called Nolo Press. Nolo Press does a lot of self-help books, and they're one of our main staples for self-represented folks, and sometimes for attorneys who are working in areas they're not too familiar with. They'll get a good start here too. It has samples. This particular one, Win Your Lawsuit, has samples that go through some of the stuff we've talked about today, and then continuing on from there through discovery and trial. It's a very useful resource. And we have ones that are more specifically topical, like Win Your Personal Injury Claim by Nolo, and a bunch of different topics as well. We have these action guides, this from a company called CEB. As Eric mentioned, they're kind of like Cliff Notes for lawyers. They often have step-by-step instructions, exactly what to do to address a particular situation. And then we have, kind of in the last level of sophistication or complexity, we have practice guides. These are quite detailed, as you can see. This is just one of a 4-volume set. And this particular one is civil procedure before trial, so it covers the kind of thing we've been talking about today, and it covers it in great depth and has research if complicated issues come up at any point. So those are things that we often recommend that people take a look at, mostly for the samples and also if they need to get into further research. There's 2 other sources I'll mention, and then we'll just wrap up. The California Forms of Pleading and Practice is a set of books. It's 52 volumes, I believe, maybe 54 volumes, and it covers practically every topic under California law you can think of. And what it does is it explains in a fair amount of depth what the elements of a case are. Eric mentioned you have to prove certain things to win a lawsuit for a contract. You have to prove that there was a contract, that it was accepted, etc. Pleading and Practice will have a chapter, and it'll tell you about that in detail. And then it'll have a sample of a complaint that you can use, or another, later in the case, it'll have a sample of answers, demurs, lots of different forms that will be helpful as the case progresses. And the last thing I'm going to mention is the jury instructions. Jury instructions are useful for 2 purposes. At the end of a trial, the judge will give these instructions to the jury so that they know what they have to decide in order to find for one party or the other. So again, with the contract example, the judge will say, in order for the plaintiff to win, you have to find that there was a contract, that there was agreement, that there were all those things that we mentioned. The jury instructions lay that out, just bare bones. Contract, agreement, etc. It's a good way to actually see the elements of a cause of action stripped bare, so that you can get a real good idea of what exactly you have to prove. And then the book that we have on that usually goes into more detail as well. And we'll sometimes give you case citations or statute citations to help you get started with your research as well. Our website has information on it. A lot of times people want to do the research on the internet, especially if they're working from home or in the evenings. We have links on our website to get you started for that primary law, links to the California statutes, California cases, regulations, and then the equivalent for federal. Also some local things such as the Sacramento City Code and County Code. Here are some useful resources. These are all things that we recommend that people use quite often, and Eric mentioned at least a few of them. One thing that can be really handy if you end up using a form, creating a form that is not pre-printed, you'll need what's called pleading paper. It's the paper with the numbers down the side, 1 through 28, and it's required for court filings if you're not using a pre-printed form. And we have a sample of that on our website that you can open up from anywhere using Microsoft Word and then use that as your starting point. It is also possible to do it using Microsoft Word built-in macros, but ours is all pre-formatted and set up, so it can save you some time there if you're not familiar with it. So that's pretty much it. We have a few different websites here that we were going to give you just a chance to take a look at the exact websites. And this is primarily for the benefit of the video camera. But we have all this information downstairs in the library. If you need it, we have handouts with the websites and a lot more information as well. So feel free to ask us if you have any questions. And thank you very much. I appreciate your attention, and have a good Saturday.